Hello, this is UCL Uncovering Politics, and today we're looking at the UK's constitution. What form does it take, and is that changing? Hello, my name is Alan Rennick, and welcome to UCL Uncovering Politics, the podcast of the School of Public Policy and Department of Political Science at University College London. Most countries have a document called the Constitution, a legal text setting out basic principles of how that country is governed. And in most of those countries, there's a constitutional court or Supreme Court that determines whether the ordinary laws passed by the legislature are compatible with the Constitution, and that strikes them down if it concludes they are not. The UK, famously, has no such capital C constitution, no codified rulebook, and the courts here in the UK can't, at least formally, strike down laws on the basis that they contravene higher law. So what kind of constitution do we have? Well, it's often said that in contrast to the legal constitutions found in many other countries, the UK has a political constitution, a constitution whose norms are enforced in the realm of politics rather than in the realm of law. But many think that the UK's political constitution is today under threat, with potentially serious consequences for the polity's ability to serve all those who live within it. So today we ask the question, does the UK still have a political constitution? And to do so, I'm very happy to say that we're joined by one of the leading experts on constitutional theory, Professor Richard Bellamy. Richard, who is Professor of Political Science here in the UCL Department of Political Science, is the author of 10 monographs. Most relevant for our conversation today is Political Constitutionalism, a Republican Defence of the Constitutionality of Democracy, published by Cambridge University Press. Richard, welcome back to UCL Uncovering Politics. You were on our very first episode back last October. Can we start with a definition? What is a political constitution?
In some ways, a political constitution is what it says on the tin. It is that the constitution resides in the workings of the political system. But to explain what that means, it's best to contrast it, as you did in your opening, with a legal constitution. When people think of a constitution, they tend to think of a written legal document that codifies how the political system should operate, what the respective roles, the legislature, executive are, how you elect the legislature and so forth, and a set of values that the Constitution should uphold. And that operates as a sort of higher law, which dictates how politics should operate. So at one level, you might sort of see it as being outside of politics. But by and large, those who advocate such constitutions believe that they do have some form of political legitimacy, that they operate, as the American Constitution famously put it, as something which comes from we the people. So there's a kind of populist element there. Now, what the political constitutionalism says or starts from is all of those rules that go into a constitution are ultimately subject to political debate and contestation. And the sort of values that you're trying to uphold through a constitution are things which people should be able to debate about and do so in a kind of organized way, which means that everybody has to actually debate with others rather than force it upon other people. And so a political constitution says the way in which all of that discussion about what laws we should have, what values should they be upholding, is something which takes place through politics. And it's how the political system operates which makes it constitutional. So that's important because in the UK, we think of the source of the constitution is Parliament. It's Parliament which is sovereign, not the people who are sovereign. And some people dislike that. But therein you have the distinction between a legal constitution and a political constitution. For the legal constitution, it's the people who create this document. But for the political constitution, the people only become, in a sense, they only operate politically and constitutionally through institutional mechanisms. And that's why it's important that they exist, that Parliament exists, because it's through that power, in a certain sense, gets controlled. And of course, the Constitution then becomes the evolving way in which people, through these institutions, refine their laws and refine the ways in which the political system itself operates.
So many people, I think, who are used to the idea of legal constitutionalism will think a political constitution is basically the same as no constitution. It's just a situation in which those who win power can act as they wish, essentially. How is a political constitution different from no constitution?
If you compare, for example, a parliamentary system with an actual dictatorship, in an actual dictatorship, you may well have a written constitution. Indeed, these days they generally do have such constitutions, but they're what are often called facade constitutions. That is, they do have some kind of constraint. So both Nazi Germany and Stalinist Russia had written constitutions, although, a prime element of them was whatever Stalin or Hitler said went, as it were. But nonetheless, Stalin famously had show trials, so did Hitler. There were certain elements that went through. And so the effect of that constitution was to solidify that hideous regime. If you have a parliamentary system, you do have within it various forms of checks and balances. And it operates, therefore, as in a way, as a system which does regulate itself. Lord Hailsham famously called the Labour government of the 1970s, Jim Callaghan, that it was an elective dictatorship, something which people then thought was much more true of Mrs. Thatcher's regime government that Lord Hailsham was very happy to serve under. But Callaghan and Mrs. Thatcher, in a sense, had to win elections, where they had strong opposition from contending parties. They had to put their proposals to Parliament. They had to operate within the context of laws that have been passed by previous parliaments and subsequent, and I'm sure we're going to talk about this in a minute, subsequent to that, Tony Blair first administration passed a number of what you might call constitutional laws, that they're ordinary legislation, but like the Human Rights Act, and there are several of these constitutional laws which are on the statute book. And although they can be changed by Parliament, and there's a consideration at the moment about changing quite a number of them, when that happens, there is quite a wide debate, and it is a constraint that they exist there. In other words, it isn't that you can do whatever you want.
Obviously, a legal constitution would also have, or could also have, these various elements within it.
Sure.
But so what the difference between a legal constitution and a political constitution is that in a legal constitution, those various elements are themselves underpinned by this legal text that is enforceable by a court. Whereas in a political constitution, you're saying, I think, these things are underpinned by something. So it's not like there isn't a fundamental constitutional layer here.
Sure.
They are underpinned by something, but that something is not written law that is enforceable by the courts. That something is rather more to do with norms that are upheld through political discourse and discussion among people. Is that fair?
Yes and no. I mean, even legal constitutions require tacit public support to a degree and are surrounded by convention. So in that sense, there's no difference. The political constitution, it is the operation of the political system that you have to go through a number of steps, winning majorities in the country, in Parliament, operating consistently with what is already settled law. So the courts do have a role in political constitution, in upholding the laws that have been duly passed by the Parliament. So even to change the constitution within a political constitution requires a certain amount of effort. But it's more clear that where the action is, if you like. So it's saying the Constitution is what it is because it's gaining popular legitimacy of a certain kind, which isn't actually simple majoritarianism. It's getting popular legitimacy which gets assent of people through a kind of discursive debate, through convincing various people and not just imposing it upon them. So in that sense, it is a more articulated system than a simple phrase like elective dictatorship.
Yeah, so we're going to be exploring this question of whether the UK still has a political constitution. Before we get on to the possible changes that have been taking place in the UK, do we need to say anything more than we have about what the UK's form of political constitution has traditionally been? And we've talked about the kind of abstract concept of a political constitution. Do we need to define what the British political constitution has traditionally been?
I mean, I think historically, I think you can say that it's had sort of three phases. So a first phase came about in the 17th century when we moved from a monarchical constitution, political in its way, to a parliamentary one. And there was a deliberate invocation in the 17th century of a sort of republican model of political constitution, which goes back to the Roman times or even ancient Greek times, which was the model of what's called the mixed constitution. And there, the thought was, well, you have sort of three orders in society. Well, you actually had more than three but three enfranchised orders. You had the common people, those who had the franchise, that was normally propertied men. You had an aristocracy, and you had the monarchy. And the thought of the mixed constitution was that all of these have distinct interests, and if you want government which is in the interests of the Commonwealth as a whole, then you needed to have a balance between them. And so the aim was to have this balance between people and aristocracy, and indeed, where you had a monarch, also the monarch. And in a sense that, although we don't think of our societies as being class status societies in that same way, the rough thought is much the same within a political constitution, that what you want to do is somehow get a balance of the contesting interests and values within society, so that they each speak and convince each other in a way that then can articulate what is in the common good of society as a whole. Now, what happened in the 18th, 19th century is that Parliament, and in particular the Commons, became the area where everything was happening. And so no longer the monarchy became part of what Badger was called the dignified constitution. It had no real power. It was just a kind of ornament there and gradually the aristocracy within the House of Lords have become likewise part of the dignified constitution. And you had a period when, in the 18th century, when Parliament was basically just ins and outs. It was people who were in office and against people held to account by people who are out of office, but they all came from representatives of the elite because the franchise was very restricted, or where it wasn't, highly corrupt and bribable. But as you developed representative democracy, you've got a new kind of balance. You've got the balance between those interests represented by different parties. So in the sort of 20th century, you got the emergence of the Labour Party as a representative of the working class and born out of unions, etc. And you've got the Conservative Party, the party of the propertied and of capital. And whilst elements of that still exist, we've moved, I suppose, more to a world where, yes, there are different interests represented by the different parties, but even more, perhaps, different views of the world, of different ideological views of the world, different understandings of what will make counts as good government. But again, the logic is still the same, that somehow there's a form of balance and contestation between them of a kind of constitutional kind, which means that you've got to at least some degree, hear the other side and convince various people. You've got to go fishing for votes, which force you not just to win through convincing your solid supporters who might get you so far, but not, you've got to convince a broader group that you actually have something to say for the national interest. And it's that forcing which in a sense operates to render politics have this constitutional form. And that's why I say the institutions of politics are where the constitution lies. It's not just the people or the voice of something called the people. It's more articulated.
So one more question before we move on to how things might have changed. So one more question about the kind of traditional setup. It's often said that in traditional UK politics, and Helsham said it, as you mentioned earlier, you win power, you win a majority in the Commons, and then you can enact whatever laws you wish. You are essentially unconstrained, that it doesn't matter what nice discourse might happen in Parliament. The government, if it wants to win, will win anyway, and that's all there is to it. Is that a mischaracterization, in your view, of the traditional British Constitution?
I think it is. I mean, it's not. Of course, there are elements of it which have a superficial veracity, as it were. But even prime ministers who have large majorities, as the current prime minister does, first they have different factions in their own party that they have to sort of palliate and listen to, even though to some degree the current prime minister has an opportunity to purge his party. He's got, different wings of it. He also needs to at least appear to be doing things in the national interest, and that is a kind of constraint upon him. He won a lot of, the famous red wall seats that he won. If he wants to keep those, and it seems that he might have to, given electoral geography is changing somewhat, that also is a constraint upon him. So he, when you think of a prime minister who has quite a large working majority in Parliament, it nonetheless is one which he can't just take for granted. He's got to think about it both prospectively in terms of winning the next election and in keeping his coalition on board. He's also subjected day in, day out to criticism from, the loyal opposition. I mean, of course, it's interesting how at present, because we do have a national emergency with COVID, the government has tried to delegitimize criticism of its policies on the ground that it's not patriotic or whatever, or they're doing their best and there should be national unity at this time. But I mean, I think on the whole, people think there should even be more criticism of them, because that's how they keep their policies sharp. And even in these times, there has been, to varying degrees of success, quite telling criticisms of the performance of the government by an opposition which remains an official part of the system, as it were. That fact that it's Her Majesty's loyal opposition. It's their duty within the democratic system to make those criticisms and keep the government on its toes. So I think people are too cynical, I think, about the operations of the system. It doesn't mean that it couldn't be a lot better. But that phrase, "oh, it could be better, but it's true of all," shouldn't be taken as an excuse not to want reforms and not to want revisions. But I think the prospect that they could happen is also what's important, and it's a realistic hope that one can have of opposition parties that they will bring reforms about, I think.
And are kind of extra parliamentary elements important in that as well? I'm thinking checks and balances provided by very vibrant media, by independent civil servants, for example. I mean, do those count as being part of the political constitution that we should think important in the UK?
Yeah, very much so. Very much so. And of course, and to some degree, the legal system operates as it's within the political system. I tend to think. I mean, people sometimes sort of want to depoliticize completely the legal system and the operation of. But I think it's again a little bit more complicated than that. I think what one wants are independent judges operating within a part of the judiciary, which is the judicial branch, which is part of the political system. They have a political role to play, and they do that very effectively by reminding Parliament that it has to operate within the laws that it itself has made. So, in a sense, Parliament is subject to its own jurisdiction, and it's perfectly right, I think, and consistent with political constitutionalism that the judiciary does perform that role. I mean, that's something which is contentious at present in the aftermath of the Miller case. But I think from my perspective, that was a perfectly Miller 1 anyway, was a perfectly respectable decision within the terms of the political constitution.
So Miller 1, just to remind people, was the decision that Parliament had to decide that the UK was going to apply for leaving the European Union. The executive could not make that decision on its own, even though there had been a referendum, because the referendum formally was only advisory. So let's move on then to think about how things might be changing. And I guess if we're asking the question of whether we still have a political constitution, we might be thinking that our political constitution is being replaced by a legal constitution, or we might be thinking that it's being kind of eroded and we're moving in the direction of no constitution and no adequate checks and balances or constraints on power. So let's think about the first of those first. You mentioned earlier the Human Rights Act passed in 1998, came into force in 2000. Under which the courts can now declare that law is incompatible with, in a sense, higher law, the European Convention on Human Rights. And indeed, while we were still in the EU, which of course we're not anymore, EU law had precedence over UK law, and the courts could actually strike down UK law on the basis that it was incompatible with EU law. Now that element has now gone, but to what extent have we moved towards a system of legal constitutionalism where the courts in the UK do actually sit above the political elements of the constitution?
I don't believe that's so. I mean, I should say I've written a kind of trilogy of things, well, one on the Human Rights Act, one on the European Convention of Human Rights, and then a whole book on the EU, which are more or less designed to show that the political constitution is still up and running. So with regard to the Human Rights Act, I mean, one way of understanding it is that it was enacted in a way to keep the political constitution alive at a time when, largely because of what had happened in during the Troubles in Northern Ireland, the UK had been subject to a series of adverse judgments about what has was tantamount to torture by the armed services during that period. And so the argument was, well, the European Convention rights are these days uncontroversial to the vast majority of people, of course. But it's not that they find the abstract rights themselves controversial, I find. So the thought was, well, maybe it would be a good thing for Parliament itself to do a kind of pre-check of this, and for British courts to also do a pre-check. So that's in part what the Human Rights Act requires. It requires that Parliament first ask itself, but the minister proposing legislation has to say, I think that this is compatible with human rights, and these are my reasons for doing so. So one thing you could say, well, that's a way of kind of giving a steer to courts about, you think rights are important, but what you're doing is you're giving a steer to Parliament. And in fact, this element has now become something that through the Council of Europe, which is the body that oversees the European Convention on Human Rights, and of which the UK is still a member, the UK has pushed the need for this parliamentary scrutiny for rights compliance to something that should happen everywhere, and it's spread. I mean, some Scandinavian countries already had it, but you can see this as one bit of political constitutionalism was actually promoted human rights by saying all countries, when they're considering legislation, ought to be doing this. But of course, one thing about legislatures is that they tend to look at things in general terms, and therefore they may come across, not look at particular cases always where rights might get infringed. They may not think of these possibilities, whereas courts, they have the individuals in front of them. What happens under the Human Rights Act is that courts can call out a law as having an adverse consequence for rights, unanticipated by the legislature. But that law isn't automatically nullified as a result, as is the case in the United States. Instead, it goes back to Parliament to consider it. And usually it is true that Parliament has considered, but not in all cases. Parliament can say, notwithstanding this judgment of the court, we believe that it is justified, that the law is justified. They have to give reasons for that. So in a certain sense, you can see that this is a reinforcement, therefore, of political constitutionalism, rather than it's a way in which the courts and the political system work in tandem, as they always have to. You couldn't not have the law interpreted independently by the courts. In fact, all politicians have a good interest in that happening, because they want the legislation that they pass to be effective and to be coherently and consistently applied. But that means that it's part of the court's job to say, is this true in this particular case that's come up before me? And I just see that as something which is a reinforcement of political constitutionalism, not an undermining of it.
It's interesting. Listening to you, it kind of sounds as though the dichotomy that is sometimes presented between political constitutionalism and legal constitutionalism is much less stark than we often think. So, even in the United States, famous example of legal constitutionalism, I suppose it is also the case that the courts think a great deal about the political context in which they are judging. It's not as though somehow there are just some judges who come down with an interpretation of the law from on high and that's it. It's a very political process there as well. And you're kind of saying that similarly in the UK, we have an interaction between courts and politics. It's just a somewhat different kind of interaction.
That's right. And I should say the same goes for the bad things that can happen in political constitutions. They can also happen in legal constitutions. In other words, if one thinks of what happened during the latter period of the Trump administration in the United States, more seriously in Europe, in Hungary and Poland at the moment, what you've got is legal constitution being overtaken by powers that be in order to sediment and make their power even stronger. In other words, if they didn't have that whole legal apparatus, which they've been able to essentially colonize and bend to their will, their hold on power would be much weaker than it is. And, can live on after them. I mean, President Biden, in a sense, has to live with President Trump's court. In that certain sense, the political constitution makes these political decisions more apparent. And it makes the politics, it puts it out there and without the false facade of the legitimacy of it being, a constitutional order. And a constitutional order can actually drive out political contestation. It doesn't cease to be political as a result of the driving out of the contestation. It actually serves a solidifying form of allowing people to survive in power when they lost in politics, and so that's one of the reasons why I actually favour political constitutionalism over legal constitutionalism.
So finally, and alas, this will need to be our final question, the alternative interpretation of what's going on at the moment, particularly in the UK, I guess just in the last very few years, is that we're seeing more of an erosion of the political constitution rather than a replacement with legal constitution, perhaps partly as a result of the assertion of popular sovereignty, which you contrasted with political constitutionalism earlier in the referendum in 2016. And then over the last couple of years, with a government that, in the view of many people at least, does not respect the constraints of the political constitution, that thinks that it can ignore Parliament, it can shut down Parliament, it can appoint civil servants whom it likes, it can question the independence of the BBC, for example. What would be your interpretation of what's going on there?
No, I mean, I do think that this is a danger. I mean, the one which, sadly, is not happening solely in the UK. And I think it derives from a weakening of faith in political structures. In the political parties are distanced from their electorate. The politicians belong to, they're increasingly people who are very much professional politicians. They haven't, in the Labour Party, it was common before that the people who went into politics had been very active in the trade union movement, for example. Now the trade unions are weak, and the number of politicians who've been involved in them must be minimal. I think there is a real need for politics to renew itself. However, whilst there are many people who, faced with this, sort of say, well, we need a constitutional moment. We need to have, to write a proper constitution for the UK, for example. And I'm sure this is quite popular amongst you and your colleagues in the Constitution Unit. But I think it's a diversion, and possibly a very unhealthy one, because, as I said, other failing political systems, where the populists have very explicitly taken over, have used the legal constitution to serve their own ends. If we don't want that to happen, the legal constitution isn't going to save us. What will save us is if our politics is healthy, and in part, that requires politicians to start doing more legwork, to involve people more, to make people feel that politics matters, because Her Majesty's opposition is opposing, and very vigorously so. And I would say that even if Labour Party was in power and it was the Conservatives in opposition, it cuts both ways. That's got to be the case. So I feel that it's in the hands of politicians to make politics matter. And I feel that at present that is not adequately the case, that too often politicians, they see it too much as a job like any other, as it were, rather than one which requires a constant seeking for political legitimacy from those who they're having to represent. And I think it's, how to reconnect and rebuild politics and thereby the political constitution, I think is a major task. So that's where I wish people would concentrate, because I think that's where the action is, not with the legal constitution, but again, with the political constitution.
Well, thank you, Richard. That has been such a fascinating conversation, so rich in thinking through these various aspects of the Constitution. Richard's book, Political Constitutionalism, is available in all good bookshops, and look out for his chapter on political constitutionalism, which is forthcoming in a book that will be coming very soon, a Cambridge Constitutional History of the United Kingdom. Next week, we'll be looking at the possibility of a referendum on Irish unification in the coming years. A fascinating topic as well. Remember to make sure you don't miss out on that or other future episodes of UCL Uncovering Politics. All you need to do is subscribe. You can do so on Apple, Spotify, or whatever podcast provider you use. I'm Alan Rennick. Our producer is Abby Turner. Our theme music is written and performed by John Mann. This has been UCL Uncovering Politics. Thank you for listening.